Mr. Speaker.
I call Chris Bishop.
Thank you very much, Mr. Speaker. Pleasure to take a call on this very important bill. My first contribution on a justice matter in the House, can I say, very exciting time. Although quite a sobering piece of legislation, but a very important piece of legislation, and it's good to see from listening to the debate that I have been doing that it largely has the widespread support of the House, I think, at first reading, because it's important that we discuss the matters that Select Committee contain within it. Sir, I want to limit my remarks a little bit on the suicide reporting measures contained in the bill. And this has obviously been a vexed issue in New Zealand society, the issue of the appropriate limits that are placed on the news media in reporting on suicides or self-inflicted deaths. Obviously been a vexed issue in New Zealand for many years. And in some ways, the two extremes, I guess, Mr. Speaker, in the debate can be summed up as one side says publish everything, and I guess that's the pure libertarian view would be that there should be no restrictions placed on the reporting by the news media of suicide or of self-inflicted deaths. We should have total freedom of speech. And there, I guess, allied to that are arguments about the educative or therapeutic nature of that reporting. Then, of course, sir, there is a very strong counter-argument to that, which is that the harm that arises from the reporting of suicides through contagion effect and through copycat suicides outweighs the freedom of speech for media to report that. And working through those two conflicting arguments, sir, is obviously difficult and challenging, but obviously necessary. And I think it was appropriate that the Minister of Justice and the government referred this issue to the Law Commission, because the Law Commission, in my view, sir, is the appropriate body to work through a sensitive and difficult issue where there are two competing viewpoints and come to some sort of recommendation, and I think it's the right body. I think it's interesting, sir, just to note that New Zealand is actually the only jurisdiction, or one of the only jurisdictions in the world that uses legislative force to prohibit the reporting of suicides. Every other country that the Law Commission could find uses a mixture of education and voluntary guidelines. And I, for one, sir, found that interesting, but I don't necessarily think it means it's wrong. It just means that New Zealand uses a slightly different mechanism to, say, other countries. Sir, I think there is widespread acknowledgement that the status quo is not working, that the current measures in the Coroners Act 2006 have proven to need improvement. The Law Commission, sir, in their report outlines a range of failings and a range of things that have gone wrong with that Act. They pointed to the uncertainty in the current law, uncertainty that puzzles or at least confuses in some ways the news media and the general public about what exactly is allowed to be reported. So they pointed to the fact that the current law is not actually observed in some cases. The Law Commission study suggests that around 20% of the time, sir, the law is at least not complied with in some way, and that's even in clear breaches of the law. And they also pointed to the unevenness of the law. So overseas suicides are allowed to be reported. The example pointed to in the Law Commission report is Marilyn Monroe, Mr. Speaker, but New Zealand-based suicides have a prohibition placed on them. And, sir, the Law Commission also pointed out that the law has not kept pace with social media. This is another classic example of technology running a little bit ahead of the law, something that we are grappling with in a number of different circumstances. So the Law Commission wisely, in my view, sir, recommended some changes to the Coroners Act, which has been included in this Coroners Amendment Bill. So I'd like to talk a little bit about the free speech elements of this bill, because Section 14 of the New Zealand Bill of Rights Act, sir, protects freedom of speech or freedom of expression, and that obviously applies to the news media. But it's sort of trite also to observe, sir, I think, that freedom of speech is not an absolute right. I'm a strong, as I think I said in my maiden speech, a strong believer in the importance of freedom of speech. I think as Justice Anderson, as he then was, in Hosking and Runting said, sir, freedom of speech is the first and last trench in the protection of liberty. And I think that quote for me has always summed up what free speech means, or what freedom of speech is all about, which is liberty. But sir, it's obviously has its limits, and this is the issue that we're grappling with today. Sir, I went and looked up the legal advice that was provided to the Attorney General under Section 7 of the Bill of Rights Act. Members will be aware, of course, that the Attorney General is under an obligation under Section 7 of the Bill of Rights Act to report to the House where he finds that a measure is inconsistent with the Bill of Rights Act. Now, it was first thought for a while that just a prima facie inconsistency in a piece of legislation would require the report to the House by the Attorney General. But I think starting from the outset of the Bill of Rights Act, successive Attorneys General have taken the view that it requires a report to the House when the legal advice, or at least in his or her view, not only is there a prima facie inconsistency with the Bill of Rights Act, but where it's an unjustifiable inconsistency, and that justification process is actually at the heart of the Bill of Rights Act. So, sir, we haven't had a report in this case from the Attorney General, which suggests obviously that in his mind it is a justifiable limit on Section 14 of the Bill of Rights Act. But I went and looked up the actual legal advice, because since 2003, sir, all the legal advice that goes from either the Crown Law Office or the Ministry of Justice to the Attorney has been placed online. And I have to say, sir, just noting for the House's record, I was a little bit disappointed in the analysis in the legal opinion provided to the Attorney General. In my view, sir, it was quite a cursory analysis, and it didn't fully engage in that very important justification process that the Attorney is required to undertake. And that justification analysis, sir, in some ways is actually contained in the actual Law Commission report that in some ways is the genesis of this legislation. So it was slightly disappointing to see a very cursory, I wouldn't go so far as to say glib analysis, sir, but a somewhat cursory analysis within the legal advice. I think it simply says, we have found this to be a justified measure, and there's not a huge amount of analysis or substantive detailing of why that is. So that's a little bit disappointing. But I think, sir, if members go to the Law Commission report, you will find there some substantive analysis as to why this is a justified, or why the measures that the Law Commission is recommending are a justified limit on freedom of speech. And there, sir, they go through whether or not this is a significant and important objective, and whether or not the limit that's placed on freedom of expression is a rational and proportional limit. Sir, those words are very familiar to me from my law school days doing Bill of Rights analysis. I think they come from the Moonen test, later revised to Hansen. Things that I thought I would not have to think about again, but now I fortuitously find myself in this very privileged position. So, sir, I think it is obvious that trying to prevent harm from suicide reporting is a significant objective. It is an important objective. And the question then, sir, is whether or not the limits that are proposed in this legislation, which are very narrow limits, are rational and proportional. And I think, sir, the evidence that the Law Commission points to suggests that is the case. The Law Commission, sir, points to the fact that the evidence is irrefutable that sometimes suicide reporting is strongly associated with a risk of further suicides, and they point to the fact that there is some evidence of a causal link between some form of reporting and subsequent suicides. There's a huge amount of detail in the Law Commission report, sir, and in the appendices, which I commend to members. Sir, in my view, the recommendations from the Law Commission that are enacted in this legislation are appropriate, they are wise, and the Select Committee is the appropriate place to consider any further refinements to that legislation or those proposals if they are so required. But, sir, I commend this bill to the House.